Good morning, good evening, and good night. Welcome to Better Place, Talking International Law with me, Jonathan Coleb. We hope you are all safe and well wherever you are tuning in from around the world. Today, I am really thrilled to have with me Lucy Greenwood. I first met Lucy a few years back as a coach in Hong Kong. We were both coaches of rival university teams in an international commercial arbitration moot competition. She was one of the judges of the University of Houston moot team, and I of RMIT University. I think I judged your team, and then we chit-chatted afterwards and connected. British accent, American team. It was met in Hong Kong. It was memorable connection. Lucy, you're a successful international arbitrator. And you also give of your time to not just champion the next generation of global arbitrators and global lawyers, but also to train them as well. And in particular, a champion of increasing the number of women involved in international arbitration too, which hopefully we'll get to. Lucy, welcome.
Thank you, Jonathan. I'm absolutely delighted to be with you today. And how are you, everyone?
Thank you, Lucy. Let me give the audience a little bit of your formal bio. And I do say just a little bit. It is being condensed because we only want to fit it into one podcast episode, not multiple. So Lucy Greenwood is an independent international arbitrator specializing in commercial and investment disputes. She has over 20 years of experience in commercial and investment treaty arbitrations in a wealth of different industries, and has acted as counsel or arbitrator in more than 60 arbitrations. She is a chartered arbitrator, a member of the State Bar of Texas, and a solicitor of the Supreme Court of England and Wales. Her arbitrations have involved energy, oil and gas disputes, fracking, water rights, land disputes, construction issues, coal power plants, you name it, she's done it. Lucy is a listed arbitrator on several arbitrator panel rosters, including ACICA, the Australian Centre for International Dispute Resolution, and the Hong Kong International Arbitration Centre, amongst many, many others. Lucy, thank you so much for doing this. Did I miss anything?
No, although I always smile when you mention my State Bar of Texas qualification, because I am so proud of that. I think almost of anything I've achieved professionally, it's my Texas Bar qualification, which I did late in life, back in 2016, and it was challenging, to say the least. So I am very proud to say I'm a Texas attorney. A
Texas attorney, and so well, let me get that oddity out of the way then first. So how did a British lawyer end up in Houston?
Well, yes. So I had started off my professional life in London, working for a big magic circle firm. And after fairly early on, I think just a year qualified, I was asked to go to Paris to work in the international arbitration team there. And I said, yes, absolutely. And the partner said, do you not want to ask your husband? And I said, no, he'll be fine. So we went and had 3 very happy years in Paris, came back, spent another 4 years in London, at which point my husband was asked by his company to go and work in Houston, Texas. And I sort of slightly objected to this, and he said, well, I did follow you to Paris. And I said, it's not quite the same thing, not quite the same thing. We had 3 children under 4 at the time, but we had really enjoyed living abroad. As I say, in Paris, who wouldn't? We ate a lot of very nice lunches, and I did a lot of very interesting ICC work. But off we went to Houston, Texas, and that was back in 2007, as I say, with 3 very small children in tow. And really, the thing that changed least for me was my work, because I sadly had to leave the magic circle firm that I was with in London. But I was lucky enough to get a position with one of the very big international law firms in Houston. So I carried on relatively seamlessly doing international arbitration work, just everything else in my life changed dramatically. And for many years, I was able to practice international arbitration as a foreign legal consultant without having to sit the Texas bar. I was always eligible to sit it. I never wanted to sit it. And eventually I gave myself a very good talking to. And in 2016, as I say, I finally psyched myself up and went through the bar prep and endured 3 days of exams with 4,000 other students in an enormous hangar in Houston. And as I say, it was incredibly challenging, but I did it.
Yeah, oh, you should be very proud.
That was it. And it was 10 years, 10 very happy years working in Houston before returning to London, where I am now.
Fantastic. Before we get back into your career, my obligatory CV follow-up after I regale the audience of all these amazing CVs is always, what's your favourite ice cream flavour?
I love it. Well, there's been a lot of chalk ice eating through lockdown. It's kind of been a daily thing. My mum is now saying she has a dedicated freezer just for chalk ices. So it has to be salted caramel. She's like sugar plus some extra sugar. Salted caramel chalk ice. It's the way forward, the way to get through lockdown. Trust me.
Yeah, well, I've put on a few kilos down here. COVID lockdown. Fantastic. All right. Well, back to the more serious stuff, Lucy. So so far, I have interviewed what I would call public international law practitioners. First, do you describe yourself as an international law practitioner?
Yeah, and I was pondering this before I came to join this podcast today, because as I know you'd mentioned something when you reached out to me about international law, and I was thinking, am I really an international lawyer, or am I an arbitrator who applies the governing law of the dispute that's before me? And there is perhaps a distinction without a difference there, perhaps, but just unwinding for a bit, I studied international law as part of my undergraduate degree, although very interestingly, back in those days, there was no mention of any kind of investment treaty arbitration or anything in the course. But I did study both public international and private international law, and very much enjoyed that. And then obviously in my work as counsel, I acted in a number of investment treaty cases where you were applying international legal principles. But since becoming a full-time arbitrator, I have only sat on commercial arbitrations. And I would say, if you're being a purist about this, no, when I decide the cases before me, I am applying principles of whatever law it might be. And frequently it's Texas law. I have New York law at the moment. I have a couple of cases under English law, which for many years I didn't have, but I'm starting to see those now as I get established back here. And that's not international legal principles at all. You're very much looking at the individual nature of the systems that you're dealing with. However, if you take a more broader view from international, I am dealing with lawyers from all over the world. So it is international in that sense.
And yeah, so it's certainly a version, I would say. Maybe it's transnational law rather than international law. Certainly, though, I mean, most people, when they think of international law, they think of the public international, dealing with states, sovereign countries and their interactions. And you've already alluded that there's also this thing called private international law, the rights and obligations of private actors like companies that trade and operate transnationally. There is a growing body, though, of international, or let me use the word, jurisprudence around how to resolve those types of disputes as well. And I was curious, so yes, most contracts are still focused on the domestic law, and you apply the domestic law as the arbitrator that's designated in the contract or that governs the arbitration. But do you feel like there's an internationalization, sort of well, to use the jargon, a harmonization of rules that either govern the arbitration process or the substantive contractual disputes that you're involved with?
Yeah, and I mean it's a great point, Jonathan, and I think you're right. There's been a harmonisation, certainly, of the way in which international arbitrations are managed and largely pleaded, and the cases are generally conducted. I think you have to park the investment treaty stuff separately. It has to be addressed separately. As you say, that is probably true public international law. So I think rather than an internationalisation, I think there has been a harmonisation of sort of, it's generally seen to be a sort of melding between the civil and the common law approaches to the way they argue their domestic disputes, and that works pretty well. I don't think there has been a departure as much from the underlying governing law of the contract in dispute. That said, there's a couple of very interesting articles on the interpretation of contracts by arbitrators, and how we all think that we are very much applying the individual's principles of interpretation for, say, an English law governed contract. And if we had a Swiss law governed contract, we would be applying different principles of interpretation, obviously. But there's a very, very interesting body of research which says that the majority of international commercial arbitration tribunals decide according to a very similar set of contractual interpretation principles. So essentially, commercial approach, taking into account the sort of the factual matrix, to use a very much an English law term, but really not necessarily observing the strict canons of interpretation that we perhaps think we are. There's very interesting. I wrote an article on it in Arbitration International last year, and it was drawing on some research done by Professor Carton in Canada, and it's really interesting.
We can add a link to your article
I think
in the description. It is very interesting. When I teach international commercial law, I often stress the history of the lex mercatoria, and I think just by dint of all these international arbitrations that are happening now, you can't help but develop some sort of more harmonisation just by the nature and the number of these commercial disputes. I mean, we're talking billions, hundreds of billions of dollars, perhaps, I haven't seen the last figures, maybe even trillions of dollars that are in dispute every year, that are resolved not through the court systems, but through an arbitration. So whether or not it fits nicely into the bucket of international law or not, I think it's well worth having a conversation about.
That's right. No, and if I could just jump in there, that it's a great point, because that was a source of some controversy a few years ago here in England, when the then Chief Justice of the Supreme Court here said he expressed some reservations about the fact that commercial arbitrators, English commercial arbitrators, were deciding massive cases under English law and not really contributing to the development of English law through this. But the pushback to that is that we are not judges, we are arbitrators. And whilst that might be a very fine distinction sometimes, and certainly I feel that I am there to determine cases based on the argument and law before me, but I am not there necessarily to contribute to the development of English law in a wider sense.
Right. So, I mean, that's one of the criticisms of arbitration and of international arbitration as well, that you guys are dispute resolvers in a very commercial sense, very pragmatic. Let's resolve the dispute and get on with it. Whereas one of the tasks of a court of law is not just to resolve the disputes, but to also develop the law, interpret the law, apply it to new situations, and unroll and evolve the law.
Exactly.
So let me put the perhaps the harshest sort of veneer on this critique and let you respond. Are you not with international arbitration privatizing the process of international dispute resolution to the detriment of evolving the law, progressing the law, as you put it?
I mean, I think there is an argument to that, but I also would say that the arbitration is providing a service that companies are opting for. So why should an international energy company, what obligation has that company got to contribute to the development of a national law? They are making a decision to decide their disputes outside the court for valid reasons, and we as arbitrators are providing that service. I mean, you do have to get quite commercial about this, and I think occasionally we do lose a bit of sight of this. As I say, I perform a judicial function in the sense that I'm very acutely aware of the parameters under which I operate as an arbitrator, but I am not a judge. And I really keep that distinction very much at the forefront of my mind. So I think you can argue that this is taking disputes away from the court, but it is doing so because those actors in the disputes have actively chosen a different mechanism to resolve their disputes.
Right, and free choice. They freely contract to resolve their dispute through arbitration.
Yeah. And I mean, the further question then is, are we, and again, this is something I feel very strongly about, are we as arbitrators and arbitration practitioners providing the service that they are opting for, which is another question.
Right, which is presumably, presumably they want a more efficient process, maybe a cheaper or a speedier process, or all of the above. So when you do ask yourselves that, are you comfortable that you are providing a better service?
Well, better is a difficult word, because we are providing a different service from, say, the English court, because we are providing an award which is enforceable all over the world. We are providing flexibility of procedure that they wouldn't get in the English courts. We're providing ability to select your own arbitrator or input into the individuals in the tribunal that they're not. So there are a lot of very key differences in the two services that we're providing. I am sometimes concerned that clients opt for arbitration thinking they're going to get something that they're not, and generally that comes down to thinking it's going to be cheaper and thinking it's going to be quicker. And frankly, neither of those two are true in the type of major disputes that I deal with. Right. But the question is whether that's an appropriate trade-off for the benefits that I've outlined. But also it does concern me when I sometimes think that clients have just opted for arbitration on a flawed assumption.
We've spoken a little bit about, I guess, the merits of international arbitration, but what are the practicalities of it? How are you, could you just walk us through, how are you engaged as an arbitrator, and what does an arbitration look like?
Yeah, I mean, how are you engaged as an arbitrator is a huge headache when you are, like I am, entirely on your own as an independent arbitrator and have been for 3 years. And in the US, there's quite a lot of people like me, as in sole practitioners out there in the marketplace. In the UK, it's much more common to join a set of barristers' chambers and have that kind of support when you're trying to get appointments. But the short answer is how you are engaged as an arbitrator is you are at the mercy of somebody, you springing into somebody's mind when they think of who would be good for this case. And that is a very, very difficult nut to crack, as it were. You know, when I'm writing my business plans and I'm working on my marketing strategy, good marketing comes from knowing where your work stream comes from, and because you want to obviously market more to that work stream, it is very, very difficult to analyze where my appointments come in from.
Isn't that, can I interrupt? Sorry, it is so interesting to hear the words business plan and marketing strategy come out of the mouth of an international lawyer.
I know.
Many students of law don't think in those terms, but you're a sole practitioner, and you need to go and drum up your own business. Isn't that interesting?
Well, that's right. And I think I would say I'm fairly unusual in that for me, this is not a retirement option. This is a career path, and it's something that I've really enjoyed the entrepreneurial side of it. But I appreciate that I am not the usual demographic of an international arbitrator, because it tends to be people retiring out, either out of judging or, as partners in major law firms, they're stepping down. That is not my approach at all. This is my full-time job, and it's something I work very, very hard at.
Mm. And the process of an arbitration, could you just briefly walk us through the different phases and stages for someone that doesn't know about arbitration?
Sure. So you get that lovely email or phone call saying, we're interested, are you available? And you run your conflicts checks and make sure that you have no conflict of interest in acting, get the appointment, and then you may be a sole arbitrator or you may be as a panel of 3. I'm quite often selected as chair because I'm dual qualified and I'm not a US national, so I tend to often get perhaps 2 US arbitrators with me as middle and chair, and I quite like being chair because I like control, being more in control of the process. But it is very hard work anyway. So once you're all appointed, or if you're appointed, you then have an initial flurry of work where you are getting up to speed on the papers, such as they may be, and you're setting up what's called the preliminary hearing or the case management conference, which is really your first chance to get the parties in front of you. It used to be on the telephone, now it's happening much more on Zoom for reasons, as we all know. We've all shifted seamlessly to online, which is great. And then it's really your chance. I always think there's your chance to really impress the parties, how you've got control of the process, you're setting the procedure, obviously with input from the parties, and you're setting the timetable for the arbitration, and then really your work sort of dips down a little bit as they go off and write the pleadings. You may have some flurries of disputes regarding document exchange. You may not. Sometimes the parties can resolve them themselves. Sometimes you're having to issue orders. You may have to deal with a jurisdictional challenge. But really it goes sort of up and then down, and then you ramp up again before the evidentiary hearing, which is usually in person. But as you and I were discussing before we began the podcast, Jonathan, lots of arbitrations are taking place virtually now. And then you'll have a very big piece of work. I tend to do it immediately after the hearing concludes, which is writing the award. So that's really the life cycle of it.
Which takes how long? How long do you take to write an award?
How long's a piece of string? Yeah, I mean, I really try to crack on with it straight away, because I'm a great believer in doing things fresh and not putting them off. So, but it always takes longer than you think. It is a very difficult process.
We're talking weeks and months, not
yes,
hours and days.
Exactly. Yeah. Exactly.
Interesting. Lucy, I wonder, can I take you back many, many years and just inquire a little bit about your journey to where you are? Was there a moment for you that put you on this path to become an international arbitrator, that got you into this profession? A moment?
I mean, yes, I was going to say when I was asked to go to Paris, because that's when I trotted down to the library at the firm and got out some books on arbitration. But I need to sort of step back and look at why I was asked to go to Paris. And when I joined the firm, I did my 2 years training. I very early on knew that my skill set was suitable to being a disputes lawyer, and by that I mean I liked analysing problems. Going back to years and years, I used to do logic problems all the time. I do think if you're that type of person, you're very much a natural fit for a disputes lawyer. So I had trained in the disputes department and qualified into the litigation department. It was then. There was really no arbitration going on. And then when I qualified, I was asked to act in relation to a big freezing injunction. And it was a freezing injunction in the English court, but it was in support of an arbitration seated in Switzerland. And so that was the first time I'd ever really heard of this notion that you could have a forum outside, and Section 44 of the Arbitration Act allows you to get these freezing orders in support of these essentially what I saw was a foreign proceeding. And then on the back of that, I was asked to go to Paris, at which point I thought I'd better work out what this really is all about. And
Right.
as I say, got some books out the library and went off and then did nothing but arbitration for 3 years in Paris. So
Right.
it was a bit of sort of happenstance in the sense that I was selected as the associate to go to Paris with a partner, but also it made a lot of sense. It was very much a natural fit for me.
Yeah. And if I could be so bold as to take you back further, what did you want to do when you grew up, when you were back in high school? I mean, is
I wanted to ride horses.
this...
So
And?
I had a great plan that I was going to go off to a technical college in the north of England and study business studies with an equestrian option. This was at age 16. So my parents did not think that this was a good idea at all. So somehow I was redirected at that point.
Equestrian school to law school. Totally.
Exactly. Well, Lucy, why don't you go to Cambridge and study law instead? So, you know, being relatively well behaved, I did in fact go to Cambridge and study law, but I carried on horse riding. I was in the Cambridge team, so I have a blue for horse riding, but my Cambridge career was not great because I managed to come last, second last, and last in my 3 varsity matches against Oxford. And in the final one, I was actually captain of the Cambridge team, at which point I managed to come last and fall off. So that was not a great success.
I'm sure
so
you were.
Anyway, I decided at that point that perhaps riding horses was not going to be a long-term career option. So I then really, I was lucky at Cambridge. There was a good network with the big city law firms, and I benefited from it. I was offered a job at a major law firm, and I took it.
Yeah, brilliant. Are you still riding horses?
I do occasionally, yes.
Oh, beautiful.
Still not very well.
Lucy, you have, I know you also as a great champion of women in international arbitration. Indeed, I think you were involved in a few events also for the next generation of female lawyers at Viz Hong Kong when I met you. Traditionally, I think arbitration has been seen as a little bit of a boys' club. So, you know, perhaps it's a bleedingly obvious question, but what prompted this interest in championing women in your profession?
Well, it came about. I wrote a paper back in 2011 or 2012 on the underrepresentation of women in arbitration, and I'm trying to think back to what prompted writing that paper, and I don't know. I mean, it's obviously something I've been very aware of right back to my days in a law firm in London, when I remember talking to somebody in HR, and they said to me that, you know, the average time a male associate spent at the firm was half that of a female associate, and they were rightly very concerned. And I thought then, gosh, that doesn't make sense for economic reasons, because I was a very junior associate, and I knew that the law firm had spent a lot of money on training me, and they funded my 1 year of law school. So it was not insignificant amounts of money they'd spent on training the junior associates, and to have half of the associates leave before they should was more of an economic issue, I think, than an equality issue. And so I remember that really stuck with me, that I was told the average male associate stayed 6 years and the average female stayed 3. That's significant. And then as I got more senior, after I had children, my contemporaries began to leave the profession, which concerns me. And one thing I do say to your female associates at that stage of their life, if they are having children, is just to hang in there. Just don't, you know, just hang on. Even if you have to step down, you can step back up. Just don't step off, because it's very, very hard when you've stepped off, for all sorts of reasons, you know, confidence not, you know, being an insignificant one of them, to step back on. And so I'd seen lots of my contemporaries leave. I had struggled managing children and work at a full-time job, and also but then when I started to sit down and look at this, I realised that there had been no real analysis in terms of the data. of representation of women in our field. So that's where I really dug in, and my papers on this have really focused on capturing the data, because in our field we're very good at talking about things, we're not very good at identifying defensible data, and we're not very good at taking action. So I think people knew there was an issue, but that nobody had really dug into what this issue really looked like, and then what we could do about it.
Fantastic. I mean, diversity and inclusion is something we should be able to all get behind in any profession.
Of course.
And has there been, if I may ask, a particularly depressing sort of moment for you as a female trailblazer in this field of international arbitration? And equally, if I can balance it, any particularly inspiring sort of moments that you could share?
In what sense? I'm struggling a bit with that. I mean, there have been challenges. There have been, I know that there is an extra barrier to appointing me, because I don't look like what people picture when they picture an international arbitrator. And when I picture an international arbitrator, I don't think of somebody who looks like me.
We think Neil Kaplan, don't we? Doesn't everybody think Neil Kaplan?
Well, that's right. And that's part of the social conditioning that we're all subject to. And I very much emphasize, when I speak on this, I often ask people to picture a construction worker, picture a ballet dancer, picture, and they are all gender stereotyped examples of those type of people. So there's barriers that I now probably acknowledge that I faced. Perhaps at the time I didn't really know I was facing them, because you're just plugging on and doing the best you can. But in terms of depressing moments, no, I mean, I think you just focus on doing what you do, and I feel very, very privileged to be an arbitrator. I also feel that I'm finally doing the job that I'm really, really good at, for want of a better word. My skill set for being an arbitrator is so perfect, rather than, I liked being counsel, I liked arguing cases, but I don't miss it, and I'm very, very glad to be doing what I'm doing now. So
yeah, that's a beautiful, brilliant realization too. One big sort of social issue that was not enough for you though, Lucy, you've also, I think last year, launched the campaign for greener arbitration. Seems to me it's a little bit self-serving given the surname. But nevertheless, I'm sure it's not part of your marketing plan, or maybe it is, you never know. But this is a campaign, a global campaign to make international arbitrations more sustainable, more climate friendly, environmentally friendly. Is that right?
That's exactly right. And it really came about because I was asked very kindly to speak at London International Disputes Week. Gosh, I think it's about a year ago now. And I was asked to speak on a technology panel. And as I was preparing for the panel, looking into all the technologies, I just thought, oh my God, and I knew this, but this really reinforced it for me, is that we have all the technologies available to us. Yeah. We should be using them better. We should be using them full stop. Why are we having hundreds of volumes of hard copy documents sitting behind me when I decide cases and nobody ever opens them? Why is that even happening in 2019? And I'd done about 6 months previously, I'd done a big case in Houston, and I was a little bit nervous about the technology. So I said, well, we'll have one hard copy set and the rest will be electronic. And we never needed it. The technology was fine. So I came away from my panel thinking, this is no good. And I wrote this little pledge on my website, which says that, as an arbitrator, I will pledge that I will run my cases in a more environmentally friendly manner. I will encourage my parties to provide bundles electronically, and I will also encourage them to consider taking minor witnesses through video link, not flying witnesses halfway across the world to give 10 minutes of testimony, which frankly we've all had. And sometimes you give them 20 minutes because you feel bad, but really they could have stayed at home. and then from that I started to get a lot more interest, and I started to realize that I'm just, as an arbitrator, I'm just one part in this. What about the conference organizers? What about the hearing venues? What about the law firms? What about the parties? And I was lucky enough to speak on this at a conference at an ICC conference in October and got together with some people from Deckard, Michelle Bradfield, who's now my co-chair on the committee. And they did a fantastic job in doing an environmental impact analysis of a case study of an international arbitration. So again, we wanted to get the data because talking about all this in a vacuum is pointless. And we spent time. Yeah, go on.
Sorry, no. That I was just going to say that impact assessment, I believe, is on the campaign's website, or at least a portion of it. Yeah,
that's right. The headline figures are on the website. And what we did was we took a case study from one of Deckard's old cases, and we looked at how many flights they took, how many a piece of paper they printed, how many couriers they sent, took everything into account. We even put in a number for how many disposable coffee cups they used, in those late night meetings. And we attributed a value to all of them. And Deckard worked very closely with an NGO to make sure this was spot on. And we produced the environmental analysis, and this was a big arbitration. It was like 30 to 50 million in dispute, but even so, it's the sort of cases that are around. There's a lot of those type of cases around. And it came out that the carbon footprint was such that you would require planting 20,000 trees to offset it. And that's the size of Central Park.
Wow.
And anyway, we ran the numbers again with changing the assumptions. So we said no printed bundles at all, only electronic. And obviously what you take out there is not just the printing, but you take out the transport costs of the bundles, you take out the associates' times checking the bundles, all that. And we took one fewer flight at every stage. And then we worked out how many trees you could, what you can save if you run a green arbitration. But also we ran the numbers as to how much you could save on disbursements or costs you could save. And the green arbitration was not only significantly better, obviously, environmentally, but it was 40% cheaper.
40%, 40.
40% wow. Of disbursements, So, and we really haven't done enough in terms of publicising the financial side of it. We're working on that, and we're working on doing more case studies for different tranches of arbitration. So a smaller arbitration, because I think they will still have a significant environmental footprint, even if it's $1 million arbitration. Then we're going to look at a $10 million one, and so on.
And perhaps one good thing that might come out of the COVID era is an increased interest in virtual arbitrations.
Absolutely, and also a willingness to view documents on screen.
Right.
It's so simple, but I used to get a lot of pushback from my co-arbitrators when I would say, well, my PO1 says the default is electronic. If you want to, you can ask for an individual document to be printed out, but we are not going the route where you print out thousands and thousands of pages. And I would get pushback on that. And now I'm seeing people much more willing to mark documents up on their laptops, all these things that we've been able to do, but we just haven't done. So it's really exciting. And I have to say, we won the Global Arbitration Review Award for Best Development of last year. So that's given us a really big push, and we're having people sign up to show their support. So please go to greenararbitrations.com and sign up to support the initiative, because it all helps.
Are we getting commercial plugs now? Are we?
Absolutely.
I will add the link in the description. I've got a series. I'm noting the time, Lucy. I've got a series of quick fire questions, if I may, to wrap things up. How about that, Lucy?
Great.
All right. So, what will you be working on today, Lucy, or this week? What's on your agenda?
Okay, I have an order for summary dismissal that I'm wrestling with to knock out a number of non-contractual claims from an arbitration that I'm doing as a sole arbitrator, which is a relatively large arbitration under Texas law. So a happy afternoon, spent wrestling with some fairly significant issues on summary dismissal.
And you've got a really interesting perspective, I think, on international law. I mean, especially given the conversation we had 20 minutes ago, whether or not we describe it even as international law. What do you think is the future of international dispute resolution? Let's use a different term. Do you think arbitration is the future?
I think it can be. I think we've slightly lost our way in recent years, and I think there needs to be a certain amount of reinventing ourselves and marketing ourselves as more technologically aware, more pragmatic. People have been saying this for years, but I think we can be more efficient in the way we behave, and I think that links in very much with the being more aware of environmental factors. You're seeing clients wanting more awareness of environmental, social and governance issues. I think we have been amazing as a community the way we have pivoted through the pandemic to virtual arbitrations, and I think we've surprised ourselves. We're seen very much as this certain demographic who don't do modern things, and actually that's not been true. So I think we should give ourselves some credit for that, but we have to keep manifesting that very much.
Necessity is the mother of all invention.
Yeah.
So you never rest on your laurels, Lucy. So what drives you? What keeps you going?
Well, I think, as I said, I absolutely love what I do, and that's what keeps me going, because it is tough. As I said, you don't know where your work's coming from. You have to keep. There's a lot of self-promotion involved, which doesn't come naturally to anybody. I don't think it's hard to go up to people, and I don't go up to them anymore, but I used to go up at conferences. Here's my card. If you're thinking of an energy arbitrator, please do think of me. Or if you've got a US element, I can, that's hard to do, but the end goal is very much worthwhile, really worthwhile. So that's what keeps me going. I absolutely love what I do.
Heroes. I'm curious, those that have come before you, who do you draw sort of inspiration and energy from?
Yeah, and I wrote a blog post about standing on the shoulders of giants, which is that wonderful saying about how I just really took to it. There are amazing giants in the arbitration community that I have benefited from, but in particular, I would say those women largely who really go out their way to help other women, and that's something I'm working harder on myself. And when I see senior women in the field doing that, it's so inspiring. So with that, I'm thinking of people like Juliette Blanche, who's a wonderful, successful arbitrator, but really makes a difference when she talks. She that she's going to go and deliver on what she's saying. Excuse me. And there's other really impressive women who I've just admired throughout the years. People like Edna Sussman in New York, Jean Kaliski in New York, who have been plugging away, perhaps with not the recognition they should have had, but have established themselves as world-beating arbitrators through simple tenacity, I think.
And we should be celebrating those people, those heroes. Fantastic. My final question, Lucy. You're a mentor of young law students now with the University of Houston, commercial arbitration moot team, but also all the other work you do as well. So, but in retrospect, what do you wish? What's one piece of advice that you would have liked to have received when you were a uni student?
It's that old. I don't want to be cliched, but I was going to sort of say it's a marathon, not a sprint, and all that. But I was very much conditioned to be. It was up or out, and if you hadn't achieved certain things by certain stages in your career, then forget it. And I suspect a lot of that was the time, late 90s, early 2000s, and also my sex as well, and having children. So I wish I had been told that you don't have to achieve certain things at certain times, because everyone is different, and you will get where you need to be, and where you need to be, or where you end up, may well not be where you think you want to be right now. So it's keeping an open mind. I remember writing a jokey email to my boss back in 1999 saying, when I grow up I want to be an arbitrator. And it was an absolute joke, and we had this running joke between us, what a nice life arbitrators had. And the idea that I have actually managed it is extraordinary to me. And it's not been through any kind of grand plan. it's been through having great experience in a law firm, not saying no to things. I was very much somebody who take on more work, and yes, you have to moderate that. I'm not saying anyone to kill themselves, but you know, in your early years of your career, you do have to say yes to everything and work hard, because you will get this great range of experience, and that's what you build on. It's being in the cases, seeing the arbitrators, making those connections. That's your foundation for future career development.
And on that note, Lucy Greenwood, a star international arbitrator, a champion and advocate for a more diverse, greener, more sustainable vision of international arbitration. Thank you for this conversation, and thank you for making the world a better place.
Thank you, Jonathan.